Okay, now let's go back to one of the stories we're focusing on today, because the Protection of Personal Information Act, Popi Act, came into effect today, 1 July, meaning that you can now take action against any company that uses your personal information without your consent or that abuses it in any way. A short while ago, we were joined by the Information Regulator Chair, Advocate Pansy Tlakula. She's still with us, and I'm also hoping that I'm going to be joined as well by legal expert Melusi Kulu as well about some of the legal implications. Advocate Tlakula, thank you very much for staying there. I'm not sure, I was smiling just a short while ago, pardon me, just to segue a bit. I am not sure if you were listening to my interview with Ibrahim Fakir about elections and thinking about your days gone by when you were the IEC and thinking, I'm glad I'm not having to make that decision around the municipal elections. Can we just start there in this segment?
Yeah. In fact, quite relevant because, as you know, as of yesterday, the 30th of June, the Information Regulator took over the regulation of the promotion of access to information from the South African Human Rights Commission. You may recall that in 2019, there was an amendment to PAIA, to the Promotion of Access to Information Act. That amendment has included political parties in the definition of private bodies in that act. The implications of that is that political parties have to make available, they have to record the private sources of funding that they receive. But most importantly, it means that members of the public can put a PAIA request to a political party if they want information that will enable them to exercise their right to vote. So I think as we talk about the protection of personal information coming into operation today, we forget a major issue of advancing and enhancing the transparency of the electoral process by including political parties in the definition of private bodies in PAIA. I think this is one of the first in the world, and I think as South Africans we must pride ourselves for that.
Yeah, I think that's a good move indeed. Thanks for reminding us this. I was just thinking that, just not so long ago, you were one of the leaders there at the IEC when they're grappling with this issue. Okay, on Popi itself, the complying with any regulation, I mean, is not cheap, so to speak. I think maybe that might be a wrong word. There is a cost to compliance that companies and people must have, because you might be fined quite a chunk of money if you're found guilty or you haven't complied. So you have to spend money. You have to appoint a chief information officer, for example. I mean, small businesses might not afford that. Medium size, I don't know. Big businesses. What's your view on that?
I think some of the things private and public bodies can do for themselves. For instance, the example that you have given, that every private body and public body must have an information officer, for instance. We have become aware that there are consultants there that are charging public and private bodies a large sum of money to register their information officers. We have created a portal, even if that portal still has problems. What I'm saying is that registration of an information officer is something that a company or a government department can do on their own. They don't need a consultant to do that. Yes, putting compliance systems and processes in place will require expertise, especially when it comes to ICT, to ensure that the systems are compliant. But I think private and public bodies have to weigh the cost of compliance against the reputational risk that they may suffer if they do not comply. Because non-compliance, apart from the fact that it will attract sanctions from the information regulator if there is a complaint against your company, it will also cause you a lot of reputational risk, because you do not want your company to be all over the media for the reason that they did not secure the information of persons of persons, because once you are breached, you know what happens. There are companies that are still trying to recover from the reputational risk of a data breach.
So you would encourage, I mean, that's your role obviously, but you would encourage companies as of today to rather focus on the benefits of compliance in this particular case, articulate them, understand them properly, and just do them in a comprehensive way.
And train everybody, because, you know, although there are exclusions, as I said, that journalists who are processing information for journalistic purposes are excluded from the Act, but your company, as Newsroom Africa, as a company, is still bound to comply with the provisions of the Act.
You mean eNCA? You mean eNCA?
I'm sorry. I am so sorry for that. eNCA, for, I mean, your service providers, the employees, and everyone, they still have to comply with the provisions of the Act. eNCA will only be excluded insofar as processing of personal information for journalistic purposes is concerned. And latching on to what Loyiso said, how cybersecurity links with our Act, one of the conditions for the lawful processing of personal information is that those who process personal information must put in place reasonable and adequate technical and organizational security measures to protect personal information against unlawful access. So we come in there. If you have been breached, then the Information Regulator will conduct an investigation to check, to determine the adequacy and the reasonableness of the security measures that you had put in place, both technical and organizational as well. And that's where the training of all the employees on how they should handle personal information that they deal with, that becomes very important.
Okay.
Everybody has to be trained from the security at the desk. You know, in some instances, I know in eNCA, you have someone at the entrance who takes my name and my information, put it on a book. I don't know what happens to those books that I have seen where I've given my personal information. Those kinds of things are small things that companies have to pay attention to emphasize that this Act also applies to public bodies, government departments at all levels, national, provincial, and local.
Okay. Advocate Pansy Tlakula, I'm going to have to let you go. I do have a legal expert coming up, Melusi Xulu, to get his views, but you've been so kind. You've really stayed for longer than I thought you were available for. I really appreciate it. And good luck. We will touch base with you as a regulator, and you've shared with us some very interesting facts here. And all the best in the future. Popi Act is here now. Thank you very much, Advocate Pansy Tlakula. Melusi Xulu is a legal expert. I've been talking to the Information Regulator. I don't know if you've heard a little bit about her. I'm letting her go now. But you as a legal expert, I mean, there is a cost to compliance. I mean, she agrees with that. But if you're a company today, as of now, from a legal perspective, what are the key implications of not complying with the Popi Act?
If you look at the Popi Act, if you don't comply, there is
I think
possibility of paying.
Yeah, your connection. Sorry, Melusi, I apologize. I apologize to you and to our viewers. The connection that we're having with you is not great. I still want to hear his views. We'll try and see if we can get you back, even for a short while.